Okay, well, hello everyone. My name is Catherine Fleming Bruce. I'm with Tnovsa Global Commons, and I am an independent presenter with the Atlantic Institute. And their passion and their mission is to make sure that dialogue is a part of what we do, a part of our social justice work, and that it is effective and that we kind of demonstrate good examples of dialogue. So in the show that we're doing today, we wanted to talk about Alexander versus South Carolina State Conference of NAACP. That's a case that is now before the Supreme Court. It's going to be heard on October 11th. And there are going to be a number of events happening around that day. But we wanted to take this time to make sure that people understood what is Alexander versus NAACP. Why is it important? And why should those of us in South Carolina and those of us across the nation be paying attention to this case and its outcomes? So I'm going to have several guests today, and my first guest is Mitchell Brown. I'd like him to talk a little bit about who he is and the organization that he's with and why that organization cares about Alexander versus South Carolina NAACP.
All right. Well, thank you for having me, Catherine. My name is Mitchell Brown. I'm senior counsel and the director of the SOLVE network at the Southern Coalition for Social Justice. SOLVE stands for Southern Leadership for Voter Engagement. We were created as a coalition and network after the Shelby County Beholder case in 2013, where we decided that it was necessary to bring Southern leaders throughout the South, broadly defined Southern leaders in the South, to work around voter education and voter engagement in the South, given that the federal government was no longer going to be essentially protecting voting rights in the South before voting laws took effect. And so why this Alexander v. South Carolina versus State Conference of the NAACP case is very important to SOLVE and very important to SCSJ is because it deals with racial gerrymandering. SOLVE's mission and SCSJ's mission is to fight. Part of its mission is to fight for racial justice. And racial gerrymandering, for those who may not be familiar, is the moving around of voters of color into various districts during the redistricting process in order to dilute their voting power. There's two types of gerrymandering, racial gerrymandering that we look at: cracking and packing. Cracking being splitting up voters of color throughout the state or throughout a locality into various districts in order to dilute their vote. Or packing, which is putting a lot of voters of color into one particular district when they could be split up into multiple districts and have more voting power. Again, the goal is to dilute the voting power. And so with the Alexander case, what happened is the state South Carolina legislature decided to move voters, Black voters from Congressional District 1, which is on the Eastern Seaboard and includes Charleston, and move them into Representative Clyburn's district in CD6. And when Representative Clyburn's district is a majority Black district as it stands, and so adding more Black voters to his district was one, packing them into that district, but also it was diluting the voting power of those voters who may still, those Black voters and voters of color who may still be in CD1. And the legislature said that they did this for political reasons, to make that district more Republican than Democrat. And they, in order to achieve that goal, they had to move these Black voters from CD1 into CD6. That matters to SOLVE and SSJ because the movement of Black voters into a district for partisan reasons should never be tolerated. And the dilution of the Black vote in South Carolina and the influence that these voters may have had in CD1 that they now don't have because thousands of Black voters are moved in CD6. That's an issue that we care about because it dilutes the voting power of those in CD1, those voters of color in CD1 as well. And so we have to fight back against it, and we have to hold the court accountable for upholding its jurisprudence around racial gerrymandering, which states that if race is the predominant factor in drawing a district, then the district is unconstitutional.
And I'll have to make a couple points. One is that it's really fascinating that SOLVE and your organization were created after Shelby versus Holder.
Mhm.
I think
Yep.
that's noteworthy because, there was a lot of gnashing of teeth and wringing of hands
Exactly right.
after that decision was made.
Exactly
But
right.
there are some people who got together and said, we're going to do something about that.
Exactly right. Like we had to come together as a network and as a coalition, because we had to save ourselves, essentially. And in doing so, we've created a robust network of over 250 organizations that all are geared towards helping protect the right to vote in southern states and helping to make sure that the states, localities, states and localities are held accountable for protecting the voting rights, particularly voters of color in the South. And so it's very, very important.
Right. And those states were formerly protected by
Correct.
Shelby versus Holder,
Correct.
that y'all are targeting. And now they're not. But I understand that Shelby versus Holder only took away one part of the protection. So
Correct.
what can you tell us what that part was?
Yeah. So Shelby County v. Holder was a case in 2013 that found that the formula, so for the preclearance formula, was unconstitutional. So let me explain what I mean by preclearance. Is starting in 1965 when the Voting Rights Act was first passed. In Section 5 of the Voting Rights Act, there was a preclearance provision which stated that certain states and localities, because you'll hear me use the word locales and localities, because the state itself, some southern states themselves weren't covered, but the cities and counties, certain cities and counties within those states were covered. And so it's states and localities as well. And so Section 5, which is preclearance, said that these covered states and localities that were determined based upon this formula that the court found unconstitutional, before they could pass any laws that affected voting rights in those states or localities, they had to get permission essentially from the Department of Justice, the United States Department of Justice, or a 3-judge panel in the DC District Court, to say that these laws weren't going to quote unquote retrogress the voting power of Black voters. Through this preclearance provision, thousands of laws that could have been passed and that would have affected Black and voters of color, mainly Black voters, would have come into play if it had not been for preclearance. When Shelby County came down and the court said that the formula was unconstitutional, it opened the floodgates for states in the South in particular to pass these laws that they may have been holding on to for so long to try to diminish the power of Black and brown voters in particular. And so one key thing I want to mention is that the court said the formula was unconstitutional. Preclearance itself is not unconstitutional. And so there are certain bills up before Congress, such as the John Lewis Voting Rights Act, which would add preclearance back on the table and have a different formula to place certain states and localities under preclearance. That would help, ensure that voting rights attorneys like myself don't have to quote unquote play whack-a-mole with voting laws throughout the South. We would have some protection from the federal government that would allow us, to focus on advocacy because we knew the federal government had our back. So that's what Shelby County v. Holder was about.
And now we find ourselves in a situation, and having been someone who was with other activists and advocates who fought for the John Lewis Voting Rights Act, one of the reasons why it didn't pass is because you didn't have the Congress people there to support its passage.
Right.
So that takes us right back to why voting and your protections of voting is important, because you will not be able to get those folks in who will protect your interests.
Correct. It's all very circular, that and I call it a dual prong attack on voting rights in the South. There's an attack at the ballot box itself and who has access to the ballot box. So that comes in the variety, I call it variety of voter ID laws, or early voting laws and cuts to early voting. In North Carolina, we have same-day registration that they're trying to cut. So they're trying to attack access to the ballot box itself. But then on a secondary level, they're also trying to dilute the voting power of voters. And so there's a conversation about whether or not it is Black and brown voters and other voters of color, or if it's partisan voters, so Democratic or Republican voters. There's a distinction there that the court is trying to parse. And the courts are afraid to step into about parsing the difference between race and party in redistricting. And so when you have, again, attacks at the ballot box, but then they're also trying to dilute the voting power of certain groups of people, it's a dual pronged attack on voting rights. And it allows for representatives to be in office that don't necessarily represent the needs of the community.
And that makes sense when I think of Congressional District 1 and Congressional District 6. For instance, I live in Congressional District 6, where those additional Black voters were pushed into. Congressional District 1 is now actually at a boil because of a school board issue. So the people who are on the current Charleston County School Board, a majority of them were supported by a group called Moms for Liberty. And so they had a Black superintendent for 3 months, and these 5 board members who were in the majority had a meeting and didn't inform the other 4 members. And then after a series of meetings, the Black superintendent was put on leave.
Wow.
So that is the current boil that is happening in Charleston County. In addition to that, you've had your other, a number of candidates who, not candidates, actually elected officials, I think 6 or 7 of them, who lost their seats last year after the redistricting, most of them African American.
Yep.
So those are just some of the kind of impacts on Black candidates, Black elected officials, who are going to come in and fight for the kind of things that are important to Black communities.
Right.
And so when Black voters don't have that strength and people are looking to become candidates, they may look at a district and say, well, I'm not wasting my time.
Exactly.
Because the numbers are against me.
Absolutely. And so I think that goes to a distinction. So we talk about equality and making sure that everybody has equal rights, and specifically in the voting rights context, that we have the equal right to vote. But we also need to talk about equity. And the equity piece of it, is making sure that our vote counts as much as everybody else. So making sure the Black vote and the brown vote are consistent with the white vote and are equaled out. Because if you are able to dilute the voting power of voters of color, or in this case, Black voters, then there's not equity in their voting power. There's not equity in their voting strength. So regardless of what they do, they still may not be able to elect a candidate of choice because of a pre-designed district that they've been put into. And so that's a shift in the conversation that we need to have nationally. Is equality is great, and I'm all for equality, but we also need to talk about equity and making sure that in the voting rights context, there's no dilution of the vote, and that our votes are, there's equity in the voting power.
Exactly. And what are some things that people need to know about this case if they live in a state outside of South Carolina? Does this case matter to you if you don't live in Congressional District 1, or even if you don't live in the state?
This case does matter because it talks about the entanglement of race and party in redistricting. And so let me explain a little bit about that. I'll give you some history on that. So historically, there have been lots of laws and cases around racial gerrymandering, but in recent years, I'll say in the last 20 or so odd years, definitely the last 2 redistricting cycles, with 2 to 3 redistricting cycles, there's been an influx of partisan gerrymandering. And what I mean by partisan gerrymandering is that you have a controlling majority party that is drawing districts that exclude the other party. And it goes both ways. Like partisan gerrymandering is equal opportunity. There are states throughout the country where the Democrats are partisan gerrymandering Republicans, and then vice versa.
Right.
And so it's a pariah in our society that we need to address. And we would try to address that through the court system. So in a case called Rucho v. Common Cause that went before the United States Supreme Court in 2019, we brought SCSJ and Allison Riggs, who was our former chief counsel and executive director, argued a case that in North Carolina, partisan gerrymandering was unconstitutional under federal law because it put at it a disadvantage a certain group of voters and diluted their ability to vote. This particular group of voters were Democratic voters, and there were some undertones of racial undertones in that case as well. But the punchline of that case, the ruling of that case, was that the court said that they were not going to wade into the political thicket of that case, and they said that partisan gerrymandering was non-justiciable at the federal level. And then so it was like, okay, so we said okay, and we went to state court. And just last year, in North Carolina, the state court found that partisan gerrymandering was constitutional under the North Carolina Constitution. That matters because in states like South Carolina and in states like Texas and Florida and Tennessee, I'm not picking on them in particular, but states in the South in particular, if it's not in your state constitution that you can't partisan gerrymander, then states are now using partisan means and partisan reasons to move Black voters around. And that's what happened in South Carolina. Again, the South Carolina legislature said, hey, we want to make this a Republican district because we want to increase the Republican stronghold on the state of South Carolina. And in order to do that, we have to move thousands of voters from Congressional District 1 into Congressional District 6. If the Supreme Court rules in favor of the legislature, so let me back up and say this point, the district court below found for the plaintiffs and found that this South Carolina legislature actually was responsible for racial gerrymandering and that the districts needed to be redrawn. The state legislature appealed it, and that's why it's being heard in the United States Supreme Court. If the Supreme Court agrees with the legislature, that means in other states, the state legislatures can draw districts based upon for partisan reasons, but with the movement of Black and brown voters into different districts to achieve that partisan aim. That goes against the Supreme Court's jurisprudence. It goes against the case law that has been in place for 30, 40 years. But if the court changes its mind and says, hey, you know what? This wasn't this wasn't racial gerrymandering. They did it for partisan reasons, and we're not going to touch it. That's going to have a long-ranging impact on states, specifically those in the South.
And I'm also thinking that when you talk about the partisan activity, there's a tendency in the law, and we've seen this with other cases, with people upset with what a party had done, and they took them to court, and the court basically says, well, that's a private club, and so we're out of that. And so that again kind of references what you're saying, in that we can say, hey, they're just doing their inside baseball stuff, and we're going to ignore that. But what's really going on is the racial part of it.
Correct. And I think in the Alexandria case, it was very egregious. Like, it was very egregious what the legislature did, because they moved thousands of voters into another district to reach a certain racial quota. I think the court said it was 17% racial quota in CD1, which would flip that district to a Republican district or Republican leaning district. And so, like, it is inside baseball, and we can argue to the cows come home that this is a racial justice issue. But unless the court disentangles race from party and party from race, we're always going to be stuck making that argument that, although they said it was for partisan reasons, it actually has a racial impact that the court needs to address under the court's, racial discrimination laws. And that's something that we are pushing for in the Alexander case. And by we, I mean the democracy space that we want the court to uphold, is that the court has a responsibility to look at the real reasons why these districts were drawn the way they were, and to look at what we call circumstantial evidence. because it may not be direct evidence of we did this to discriminate against Black voters. Like that, those the days of that overt racism are few and far between. And so the court has to look at, okay, state, you said you drew this for partisan reasons, but it has a distinct impact on Black voters. And oh yeah, you moved thousands of voters into this district. Why did you do that? And the court has to ask that question. And so that's part of our push, is to say the court has to disentangle race and party, and it has to do that analysis, because if the court fails to do that analysis, then again, we're stuck making the argument that, is a racial justice issue, and the state saying it's a partisan issue. And who is the arbiter of that? It's supposed to be the court.
Right, absolutely. And it's really appropriate, and I guess unbelievably salient that this case is coming out of Charleston, where that we have recently opened the International African American Museum, where there is an understanding that so many Black enslaved people came through Charleston, so many other parts of our history. And so this significant case has its roots in this history, as well as in the current situation that Black people in South Carolina see themselves in.
Correct. And I think that history, we have to tell that history. We have to tell that story, and we have to draw the connections, because what happened on Charleston shores, in the 1600s, and I would argue before the 1600s, but what happened on the Charleston shores in the 1600s has a direct effect on what's happening today in 2023. The systemic racism that has permeated this country for over 400 years, is still present today, and it is truly systemic. Where Black folks' ancestors came from. I used the John Hope Franklin title, "Up from Slavery." Like we've come up from slavery, but we still feel the effects of slavery even today, because we're at a disadvantage as Black voters. As Black voters and Black folks, we're at a disadvantage, and that recognition has to be a recognition of that. And so when you see the South Carolina legislature purposely moving Black voters around like they are political pawns, it makes you question, like, oh, we're basically, Black voters are basically property now again, where you're able to move us, you're able to move us from place to place, to achieve your partisan aims or your political aims, financial aims, or whatever. You're able to move us around like we are property. Again, and that's a direct, correlation back to 1600s when we were property. And so, like, this is very egregious. That story has to be told, and I think the court has to hear that part of the story, because you can't, like we're talking about entangling race and party. You can't disentangle history, past history, and say that what's happening today is devoid of that historical impact. Like, you can't say that. Like, what happened historically has a direct impact on what's happening today, and our failure as a society to look at it, and two, to address it is troubling, and leads to issues like we're having in the South Carolina case.
Now, on on October 10th, there's going to be some buses of folks coming from South Carolina, to make sure that there's a presence there of folks watching what's going on during this hearing. Absolutely. So why was it important for your organization and other partners to have the presence of South Carolinians at this event, at this hearing?
It's important to have South Carolinians, come up to DC, to the Supreme Court for this case, to let this court know and to let the world know that we're not sitting by silently and letting this happen to us. We're going to have our say about it, and we're going to try to, again, tell the story and tell the narrative. There's a historical significance to telling the story of how we made it over, and this, having folks come up to DC to tell that story of They tried to cut us down in this instance, but yet we rose. They tried to cut us down in this other instance, but yet we're still here. Like telling that story and continuing it to that story to today, that we're here today and they're trying to stop us from exercising our political power, our voting power, and allowing us to elect our candidate of choice. And just like before, when we won back then, we'll win again. And telling that story is very, very important. But also to show that this case matters. If nobody was saying anything about this case, and arguably many people, may not know about this case. This case going on in the radar has a lot of repercussions for voting rights across the South, which I've talked about a little bit. And so bringing this case to the national attention, similar to other cases, is going to help, drive home the story again of why voting matters and why protecting the voting power of Black voters matters, and that state legislatures can't just move folks around at their whim, at the legislature's whim, to achieve some partisan aim, especially when it comes to moving around voters of color. And that's why it's important to come to DC, and that's why it's important to let your voice be heard.
Yes, so we have been working very hard to put this trip together, and today is Sunday, October 1st. So there are a couple more days for people to sign up. So we will have that information in this show for people to find the Google Doc link that will enable you to sign up and have your seat on the bus reserved to join us in front of the United States Supreme Court building.
Absolutely.
So are there any other takeaways that you want people listening to this show today to understand about Alexander versus, and first, Alexander, who is that Alexander anyway? I think that's the Senate president.
Yes. Yeah, I believe so. I believe so. Yes, I believe he is. Yeah.
Yes. So it's Thomas Alexander.
Yep. So what I want people to know again is that there is a correlation between race and party in our country. You'll hear legislators say that they are trying to make sure that their party stays in power. Again, it's equal opportunity. Frederick Douglass said the power concedes nothing without a demand. That goes both ways. And so we have to demand the legislature to do what is right for the people that they represent. We have to demand the court to uphold its racial gerrymandering jurisprudence, and we have to demand that our voices be heard as voters of color, and specifically Black voters. Like, we have to demand that, because power is not just going to fall over. It's not going to give up. It has power. I like to say, my opinion, that power has one job, and that's to keep its power. And so, so we have to ensure that the people who truly have the power, who are us, the voters, we have the power. We have to let our voices be heard. And when our voices are diluted, or we are disempowered by the drawing of maps, we have to stand up and be heard. And that's why it's important to come to the Supreme Court on October 10th to let your voice be heard.
Yes. And I want to say that Frederick Douglass said that quite a long time ago.
Sure did. Sure did. And it still rings true today.
For him to be in a position to be deprived of all of the access to information and education that we have today, to be spitting that truth, as they say.
Exactly right.
That is wonderful. That is a wonder, and we can look for more of that.
Yes,
I will also say that we are suffering many impacts already because of some of these racially gerrymandered changes. And so we need not wait until we get to the point where we're suffering and we're saying, oh, we have to lift these burdens, because we see and we experience the burdens now. We have to come to be more vigilant about protecting these rights all the time, even when we think there's no threat.
Absolutely. And I'll say it as my dad says, you know, if you stay ready, you don't got to get ready. You
Right.
know, and so I think if we stay ready and we stay vigilant, as you said, I think we'll have a better opportunity to make those demands that I just talked about, and to hold our legislators accountable, our elected officials accountable for representing us. Like, we have the power as voters, and they work for us, not the other way around. And so when
Right.
you have legislators or other elected officials who are responsible for redrawing maps choosing their voters, and voters not
Mhm.
choosing their legislators, that's a
Right.
problem. And so,
Yes.
you know, what happened here is the South Carolina legislature is trying to choose which voters live in which district, and doing so in a manner that would solidify the power of one party, and they can't do that. And they specifically can't do that using, you know, voters of color and Black voters as political pawns in this chess game that they're playing at South Carolina districts.
Very much so. Well, I want to thank you not only for showing up today and having this conversation with me, but I want to thank you for the work that you're doing every day. You
Yeah,
know, whether we see you behind your desk or we don't,
yeah,
every day you're there working not only for South Carolina, but for other states in the South,
absolutely.
to fight this battle to protect voters. So I want to thank you for that right now.
Thank you so much for having me.
Yes, great. Well, I appreciate it. And we will go on to the next guest.
All right.